All right. While people are trickling in, I think that we will go ahead and get started because we have a lot to discuss today. So I want to welcome everyone and thank you for taking time out of your Thursday night to talk about uh, the imminent threat to our rights and to our democracy that is posed by Donald Trump's nominee and what we can do to fix that. Not just what we can do to oppose the single nominee who we must do everything that is in our power to stop, but also how we think about the role of the court in our democracy and what we do more broadly to protect our rights and to protect our communities. So I want to start by introducing our speakers. I am so thrilled to be introducing Professor Bowie. Professor Bowie is a professor of law at Harvard Law School, where he teaches and writes about federal and state constitutional law and local government law. He is a member of the board of the People's Parity Project, and I am incredibly excited to hear his thoughts on this crucial issue. Molly Coleman is the executive director of the People's Parity Project, which she co-founded after organizing to keep Justice Kavanaugh off the Supreme Court. And my name is Sejal Singh. I am also one of the founding co-directors of the People's Parity Project. The People's Parity Project is a new campaign of law students and lawyers who are fighting to unrig a legal system that puts corporate profits ahead of people's lives. That happened. We're fighting to unrig the courts. We're fighting for legislation that will give people a fair shot in the justice system. And we're fighting for the court to have a more appropriate role in our democracy. So with that, I'm going to turn this over to our panelists to talk about the immediate threats that the court poses to urgent progressive priorities. So we're going to start by, and I want to start by asking, if Democrats take back Congress, the left is poised to pass sweeping legislation to make our economy and our democracy work for working people. Large majorities of the country support a Green New Deal and a wealth tax. And Democrats are poised to pass H.R. 1, a transformative package of voting rights, ethics, and campaign finance regulations. But what does a 6-3 right-wing court mean for the progressive agenda?
I can take this one. Hey, everybody. We are super excited to have you all here with us tonight. Thank you, Sejal, for kicking us off. Really excited to be in this conversation and to be thinking about what do we do, not just in the next few weeks, but over the long term to make sure that we never find ourselves in a situation like this again. So the consequences of a 6-3 court, it is really, really hard to overstate how awful that would be. And the next few minutes talking about this are not going to be super optimistic because I think that there's no reason to be optimistic about it. I think that we need to be really honest about how absolutely dire the situation is. So the first thing I want to flag is that the court stands to impact the outcome of the election. It has been made increasingly clear over the last couple of days that it is going to be hard for this to be a free and fair election. And the chances of it ending up in the Supreme Court are looking at higher and higher every day. Lindsey Graham said, I think it was just today, that his acceptance of a Trump loss is conditional on the Supreme Court saying that Trump lost. They're counting on this going to the Supreme Court, and that's why they're trying to fill this seat. I also, while we're on this topic of the elections, want to mention that this is not just true of the Supreme Court. And obviously tonight we're going to be focusing largely on the Supreme Court, certainly on the federal court. But while we're on the topic of the need to democratize our courts, we do need to talk about the role that state courts play in this. When it comes to election litigation, much of that is almost certainly originate in the state courts, which have also been taken over by the Federalist Society, which are also working actively against the democratic interests of the country. I think a good example of this is the Florida Supreme Court, which in, 2018, 2019, 5 of the 7 justices on the Supreme Court in Florida went to a Federalist Society event, right? Like our state courts have also been taken over. So I just want to put that out there because I think it's important in this conversation. So assuming we get to January and we have somehow gotten to a world where Democrats are in power in spite of a 6-3 court in November, the first assumption we have to make is that essentially every major piece of legislation is going to make its way to the Supreme Court at some point or another. The way our system currently works, the losing side knows that they always get a second chance in the courts. So we pass the Green New Deal, we pass Medicare for All, anything happens, it's going to go to the court. It is going to be appealed all the way up to the Supreme Court, especially if it's a 6-3 Supreme Court. To get a better sense of what that could look like, I would encourage you to check out the state of New Deal legislation before this switch in time, right? Like nothing is safe. A few examples just to go to the pieces of legislation that Sejal brought up and kind of walking through some of the potential challenges that we should fear. The first, the Green New Deal. The most important environmental case that has been heard by the Supreme Court in the modern era was in Massachusetts v. EPA, which was a 5-4 decision. Like environmental protection is already hanging on by a thread in the court as it was in recent years. A 6-3 court stands to decimate environmental protection. For those who aren't familiar with Mass v. EPA, it was a case in which the Bush administration was refusing to carry out its responsibilities under the Clean Air Act to address climate pollution. The Environmental Protection Agency essentially said that the pollutants at issue didn't count as air pollutants, so shouldn't be regulated at all. And 4 justices on the Supreme Court agreed with them. And that was before we had people like Brett Kavanaugh on the court who have a history of resisting the EPA's efforts to break new regulatory ground. So Green New Deal, that's done with a 6-3 court. Sejal brought up HR 1, which is incredibly historic, sweeping democratic reform that would make our country, restore our country to its democratic ideals. We've never been there. Restore was not the right word. This is just a buffet of lawsuits for conservatives. They're already yelling at anybody who will listen that half of HR 1 is unconstitutional. They're testifying in front of Congress to that effect. Like, they are ready to go with these challenges. One of the key provisions of HR 1 is the requirement that states adopt independent redistricting commissions in order to prevent partisan gerrymandering. Conservatives are making the argument that this is unconstitutionally forcing states to act in a particular way, and so should be voided on anti-commandeering grounds. Conservatives are focusing on the campaign finance provisions, which would expand the powers of the Federal Election Commission, institute a national public campaign finance matching system. Republicans are saying that this is an unconstitutional regulation of speech. The list goes on and on, right? HR 1 would restore voting rights for people convicted of a felony. Republicans are saying that this is an attempt to override the Constitution by federal statute. HR 1 includes a desperately needed code of ethics for the Supreme Court. Conservatives are saying that this amounts to an unconstitutional violation of the separation of powers. So they're already making these arguments, right? The idea that all of the Democrats' legislation is unconstitutional is not like something that they thought of yesterday. They're preparing these legal arguments, they're preparing these cases, and now they're going to do everything that they can to make sure that they have a court who is incredibly receptive to these arguments. Last point that I will make on this is, since Sejal brought up the wealth tax, a desperately needed wealth tax, this is like basically dead in the water. There are great arguments to be made that a wealth tax is entirely constitutional. A 6-3 Supreme Court that is fighting against justice is certainly not going to buy those arguments. We could go through the whole history of this. We can, if anybody cares, at the end. It all goes back to like an 1896 Supreme Court case and what constitutes the direct tax, and is it problematic if a wealth tax would hit Silicon Valley harder than it would hit St. Paul, Minnesota. Long story short, they would strike it down quickly. So, like I said, not like a super uplifting couple of minutes, but really just want to make the point that while we're going to be talking about long-term reforms for most of the night, we also need to be doing absolutely everything in our power to stop the soon-to-be named nominee. And if we can't do that, we need to start talking about other options very, very, very quickly, because our ability to improve the lives of millions of people is entirely dependent on what happens with the Supreme Court. But maybe we can change that, as we'll talk about tonight.
So what would you say to people who say, well, this is hysterical, this is an overreaction, you know, states can always pass legislation that keeps choice safe, or, you know, Medicare is constitutional, so surely Medicare for all would be. I think we're all hearing from people who oppose action that, these calls uh, are overstating the risk?
They're not, is what I would say. That they're, um, this notion that because something has been declared constitutional once, that it will be again, is just not based in fact. There's this great quote from Jack Belkin from a while ago about how, hold on, I wrote this down. The history of American constitutional development in large part has been the history of formerly crazy arguments moving from off the wall to on the wall and then being adopted by courts. So if there's an argument that seems laughable right now, don't think it will be laughable for long. If there's an argument that seems so obvious that it could never be overturned, it won't stay that way for long. Yeah, this is I just don't think that the risk can be overstated here.
So you've outlined some of the tremendous risks to progressive change that the 6-3 Supreme Court might pose in the very, very near future. I want to take some time to talk about the history. So the Supreme Court has arguably been a reactionary obstacle for a really, really long time, right? So if we do block Trump's nominee, and at the end of this call, we'll talk a little bit about what everyone who's attending can do to join that fight. Will things go back to a status quo in which the Supreme Court is issuing opinions like Brown v. Ward or Roe v. Wade or Gideon v. Wainwright, which established a right to a lawyer for indigent criminal defendants? Or is that an unlikely scenario of what comes next?
So I'll take that. So hi, everybody. It's great to be here, and it's great to see so many people interested in what we can do to not live under a juristocracy. So even before Justice Ginsburg passed away, 2020 marked the 50th year in which the Supreme Court was controlled by conservative justices appointed by Republican presidents. So since 1970. And even that 50-year period of conservative justices on the Supreme Court is not a fluke, because throughout this country's history, the Supreme Court has been the biggest institutional obstacle to nearly every period of progressive change, from before the Civil War to more recent attempts to empower workers or rein in the massive influence of the wealthy in elections. And so that probably seems like an overstatement, calling the Supreme Court the biggest institutional obstacle. There are a lot of competitors. And it also might seem like an overstatement given cases like Brown versus Board, in which the court struck down state segregation laws under the 14th Amendment. But Brown is a good example of what's wrong right now, because here's the thing about Brown. Brown itself would not have been necessary if not for the Supreme Court. So if you think about what the 14th Amendment is, Congress proposed the 14th Amendment in part to overrule a Supreme Court decision that held that Black people could never be citizens, Dred Scott. And Congress knew, wow, the judiciary is going to be pretty hostile to everything we want to do. Instead of relying on the Supreme Court, we're going to give ourselves the power to enforce the 14th Amendment via legislation. And so then Congress passed all sorts of laws to protect the right of Black people to vote, to prosecute law enforcement officers who killed Black people in the South, to ban states from enacting discrimination laws. So in the 1870s, there were laws prohibiting discrimination in theaters and on train cars and everywhere else that people congregated. And what happened? The Supreme Court struck down all of these laws. And the biggest case that stands out, the 1883 civil rights cases, was just a series of cases in which the court struck down a Civil Rights Act on a theory that, a generation after slavery, Black people were, quote, running the slavery argument into the ground and had to stop being the special favorite of the laws. So Brown was a great, truly important decision. The Brown era, incredibly, incredibly meaningful for the history of this country. But the only reason states had Jim Crow laws to begin with was because the Supreme Court disempowered Congress from banning them. And it's not as though those precedents from 1880 have gone anywhere. Joe Biden proposed the Violence Against Women Act. He talked about that a lot in the DNC in 1994. The Supreme Court struck that act down. And the reason the Supreme Court struck the act down was because it invoked the same 1883 decision that struck down the first Civil Rights Act. So these precedents are ongoing. The Supreme Court has just generation after generation stood in the way of attempts at redistributive legislation or creating a multiracial, anti-misogynistic democracy. But even if you take the cases that have done well, like on their own terms, like Brown, think about what happened. So 10 years after Brown, in 1964, something like 1% of Southern schools were desegregated. So not much change in a decade. But then Congress intervened, and Congress passed the Civil Rights Act, and it told states, look, if you have segregated schools, you're not going to get federal funding anymore. And what did states do? They started desegregating their schools. And by 1970, Southern schools were more integrated than Northern schools were. And when the cases reached the Supreme Court challenging those laws, the Warren Court, to its credit, said, look, Congress can do this. Congress can interpret the 14th and 15th Amendment. But then what happened? The same thing the court usually does. It stepped in and said, stop doing that. And in the 1970s, it shut down desegregation campaigns. It made it more difficult to prove constitutional violations. And the next thing you know, you can't even have a voluntary desegregation program. And now this court is undermining even the laws from the 1960s, like the Voting Rights Act, by making up new doctrines. Molly mentioned that it's not that difficult to come up with a constitutional argument, and Shelby County is a good example. Right now, I was looking up some of the judges that the current president has nominated. One of his most recent nominees said paper money is unconstitutional. And as we just saw, the 11th Circuit said that a poll tax is not a poll tax so long as it applies to felons. So, there's no area of law that the Supreme Court considers inherently off limits for its own review. And there's no reason to expect that the future will be any different than the past, even if this nominee is not confirmed to the Supreme Court and we still have a 5-4 conservative majority. And even though I've just been picking on Brown, which again, I love, I think it's an incredibly important decision. But the same thing can be said about all the other decisions I like Roe or Obergefell or nearly every other sort of like landmark liberal decision. The reason the Supreme Court is the only institution that is capable of legalizing something like same-sex marriage around the country is because the Supreme Court currently restricts Congress from doing what Congress proposed the 14th Amendment to do, to pass laws banning states from doing things that are bad, like banning same-sex marriage. And so the consequence of all of this is that when a woman at the end of her career in her 80s dies, basic rights that millions of people have taken for granted are suddenly vulnerable. And so I've been joking this week that it's like living in the Habsburg Empire, where someone dies and all of a sudden it's a change of regime. And that's not a democracy. It's hardly a 21st century government. And so it feels like, to say that, yes, we can stop this one nominee, things will go back to normal. You have to ask, is normal, or at least, last year, really the best we can do?
That is a sobering history. So I guess the question is, what can we do about it? We are looking at a future where the Supreme Court is once again a threat to every progressive priority, where 6 unelected right-wing justices can strike down every piece of legislation we pass. So what do we do besides fighting tooth and nail to stop this nominee? What do we do about the risk of a renegade judiciary?
So I can jump in. There are, I think tonight we're going to talk about two kind of categories of reform, and I can start by talking about changing the composition of the court, changing kind of who's on the Supreme Court, which is something that's been talked about a lot, but I think there's kind of walking through the options that are on the table. So the first option that people have been talking about extensively is the composition of the court. When it comes to changing the composition of the court is court packing. So this is, expanding the court, adding a number of seats to compensate for the fact that Republicans have been appointing a number of justices, many would say illegitimately, over the last several years. This is something that there is a ton of precedent for, right? There's nothing in the Constitution that says that we have to have 9 justices. The number of justices on the Supreme Court can be changed by statute. It's been changed a number of times in the history of the country. It's been changed not by statute recently. In 2016, Mitch McConnell kept Antonin Scalia's seat open for 10 months. We had 8 justices. So it's quite precedented. I will say that people are acting like that means that it definitely would be seen as constitutional if Democrats tried to add seats to the court, if they tried to add 4, 6, or 10 seats, as some people are proposing. It hasn't been done by statute since 1870. So there is, I wouldn't necessarily say that we know for sure that this would be upheld as a constitutional maneuver. That said, it should be, and there are great arguments that it is constitutional. This is a clearly political move, right? It's saying that there are too many Republican judges on the bench, too many Republican justices on the bench, and we need more Democratic justices. It's essentially saying that the Republicans have created a judicial body that is entirely out of step with the will of the voters. Presidents who have lost the popular vote have been nominating justice after justice after justice, who they're being confirmed by senators representing less than half of the population that this is a completely undemocratic system. And so if we win a majority of the vote, Democrats should put more judges on the bench, justices on the bench. The biggest pushback here is that it's going to set off a nuclear race, right? That's what people are saying. This idea that if we add 5 justices, they'll add 7 justices, and then we'll add 15 justices. And all of a sudden, we're going to have 500 justices on the Supreme Court. And what is that doing for us? The thing that I would say to that is that this isn't starting a war, right? Republicans have shown over the last 4 years that they aren't playing by any of the same rules that we are. They change the size of the court when it suits them. They change the rules about when you can appoint a nominee and when you can appoint or nominate a justice and when you can't. So responding to that is not setting a ball in motion that we can't stop. The Republicans have set a ball in motion, and there is an obligation to respond, because the idea that only Republican presidents can appoint Supreme Court justices, which is essentially the world that we're operating in right now, is simply not a world that's acceptable. So that's court packing. And again, that's one that we're hearing about a lot, and that there are a number of groups that are trying to make that more of a mainstream proposal than it's been considered in the past. The next option, it's certainly the most popular option that is on the table, one that polls really, really well, is enacting term limits. So under this proposal, justices would be appointed to singular 18-year terms. They'd be staggered so that one justice is retiring every 2 years. Every president gets to nominate 2 justices every term that they're in office. After the justice leaves the bench, they would take senior status, or they would become a judge on one of the courts of appeals. There are some people who argue that this could be done by statute. That is probably not the case, certainly not with this judiciary that Trump has spent 4 years creating. It would almost certainly have to be done by a constitutional amendment, which is not easy. This is certainly a political outcome. It's saying that there are Democratic judges and that there are Republican judges, Democratic justices and Republican justices. It doesn't purport to eliminate that, but it is trying to create a balance that's reflective of the election outcomes. I will say that that assumes that we have elections that represent the will of the voters. So if we are electing presidents who are winning without a majority of the popular vote, we're still going to have a disproportionate number of Republicans compared to the will of the voters on the bench. That said, it is a way of eliminating the randomness, eliminating the chance of one president having 3 SCOTUS nominees in 4 years in office, and somebody like Obama having, somebody having 2 nominees in 8 years. It also deters strategic retirements. It means that you hopefully it eliminates much of the element of chance, although certainly there's the possibility of an unexpected opening. The other reason that people are really into this idea, right, is that when we started having life tenure for Supreme Court justices, average life expectancy was like 30 years less than it is now. This is reflected in the fact that for the first 200 years of the existence of the Supreme Court, justices served on average 15 years. They now serve closer to 30 years on average. So justices are spending a very, very long time on the bench. Republicans are putting them on the bench younger and younger. And this is an attempt to mitigate the harm of that. The third of 4 options that I'm going to talk about, although there are other proposals out there, is the panel system. This would essentially add to the number of people on the Supreme Court, but not in the same way that court packing would. So it would mean that instead of the entire court hearing every single case like we have now, there would be a system put in place by which a smaller number of judges heard each case. And those cases would be heard by a larger number of justices who would likely be currently sitting judges on the Courts of Appeal. So it's an interesting proposal. There are a couple of different strands of this proposal. One is the idea that the panels could be selected totally randomly. Other proposals suggest that each panel would have to have some sort of partisan balance, looking at the party of the president who appointed each person on the panel. Under some proposals, a panel's decision could be, reheard en banc, like in the current Courts of Appeal setup. In some cases, they wouldn't be eligible for en banc review. So there are a few different strands of this, but that's the general idea. And then the fourth that I wanted to touch on briefly is one that's gotten a lot of attention lately because it was originally proposed by Epps and Siddharaman in a law review article, I think in the Yale Law Journal, but it was adopted largely by Pete Buttigieg during his presidential campaign. So it's got a lot of attention and like a lot of airtime on podcasts during whenever the presidential primaries were still happening. So the idea under this proposal is that each major political party, i.e. the Democrats and the Republicans, would be allocated 5 seats on the Supreme Court. And those 10 justices would work together to pick 5 additional justices. The idea here is that you have sort of these non-ideological justices that everybody just thinks are like great jurists who can look at the law and find the truth within it. If you cannot tell, I'm pretty skeptical of this. I think for many, it's not constitutional, most likely. But also, I think there's this idea that we can have like nonpartisan judges or nonpartisan justices. And I just don't know how you could look at the jurisprudence of the entirety of our country and think that there are like non-ideological judges. So really what we're talking about is finding like centrist judges. Why having centrist judges is preferable to having non-centrist judges is, I think, an open question. It also, like, the idea that we're going to find the compromise person between Clarence Thomas and Elena Kagan, and that person will be a good justice for the future of our country is a notion that is really has been underprobed, in my opinion. So sorry, really like put all my cards on the table on that last one. But those are some of the big ideas that I've been talking about when it comes to kind of changing the faces that we see on the Supreme Court.
Great. Thank you for that very comprehensive rundown of what else is, what's on the table to change the composition of the Supreme Court. So I want to transition us to talk about some of the other options that are on the table. Whether or not we pack this court, progressives might wonder why 5 or 6 unelected Harvard and Yale graduates get to have so much completely unchecked power to overturn decisions that we make through the Democratic branches. When the right is in power, congressional Republicans have made it harder for the federal judiciary to interfere with their conservative priorities. And progressives might wonder, are there steps that we can take to shield H.R. 1 or the Green New Deal in the same way from a hostile judiciary?
Yeah, so I think it's just really important to remember that we don't have to live in a world in which we are ruled by judges. Whether we're a democracy or a republic, neither puts judges in charge of what legislation can improve our lives. That's why we have elected legislatures. It's why we are a government of the people. And so a court that's friendly and deferential to Congress is better than one that's hostile, but those aren't the only two options. So, I mean, I think it's pretty difficult to predict the future after 2020, but I will go on the record and predict that if nothing changes with respect to courts and Congress nevertheless passes something like HR 1, what will happen is a district judge, probably in Texas, will issue an injunction. HR 1 will not take effect, or at least some parts of it will not take effect. Then the Fifth Circuit will approve whatever the district judge did. So HR 1 will still not take effect. And then the Supreme Court may or may not approve what the lower courts did, but now it's 2 years later, this provision still has not taken effect. And now the Democrats who passed it have been voted out of office because they have just sat on their hands while courts stop all of the things they were elected to do. Even if in the end it turns out to be constitutional, that's still 2 years of litigation that has stopped Congress from acting. So I think it's just important to ask, okay, so if Congress is going to pass HR 1, what else should Congress do in order to make sure that HR 1 takes effect? Especially given that it's not as though anyone wants Congress to pass unconstitutional legislation, but we're in a country where people on the judiciary think that paper money is not constitutional, or that new constitutional doctrines can apply to novel laws. So the Constitution itself gives Congress the power to constitute tribunals, to make exceptions and regulations to the Supreme Court's appellate jurisdiction, and to make all laws that shall be necessary and proper for carrying into execution all of the government's powers, from the president's powers to the judiciary's powers. So all of that is just a tremendous amount of power that Congress has with respect to the judiciary. And you know who knows that? Republican members of Congress, because they take advantage of it literally all the time. Whenever they pass a law, they tend to include some sort of protective provision within that law to prevent judges from invalidating it or from disrupting it. But it's really a bipartisan thing. I don't want to just pick on Republicans because this is something that would affect all future legislation. But some of the things that Congress could do to protect something like HR 1, the first thing is what's called jurisdiction channeling. So Congress can control who hears or who considers constitutional challenges to its legislation. So for example, in the 1940s, right after World War II began, Congress passed price control legislation. And Congress thought, oh man, you know what courts are going to do? They're going to strike down all our price control legislation. How can we stop this from happening? I know. Let's create a court. We'll call it the Emergency Court of Appeals. And if you ever want to challenge our price control legislation, you have to bring your challenge in this court. And you know what else? We'll also specify who the judges on this Emergency Court of Appeals are. And so the Emergency Court of Appeals just is the only court that's considering constitutional challenges to these laws. And so some people in criminal cases who had allegedly violated the price controls, they said, hey, this law is unconstitutional. You can't convict me for violating this law. And the Supreme Court said, well, yeah, but Congress can decide who can consider challenges to its legislation. So you have this special court created by Congress that is given exclusive control over reviewing challenges to its legislation. And that was a World War II court, but we still have courts like that today. So the FISA court is a good example of the FISA court to review challenges to orders with respect to foreign intelligence and surveillance. There are a lot of other sort of specialized courts that don't have this insulating effect, but it's totally within Congress's power, at least within precedent. Another form of jurisdiction channeling is just specifying which existing court can hear a challenge. So when Congress was worried about the Voting Rights Act and thought, oh man, we're going to pass this law, what's going to happen? The courts are going to strike it down. They just included in the Voting Rights Act a provision that said, if you want to challenge this, go to the District Court for the District of Columbia. You cannot go to the Southern District of Texas. And Congress knew the District Court for the District of Columbia is full of people who like things like the Voting Rights Act. So it's partisan motivated, sure, but it's also acknowledging the reality that when you pass legislation, it's a political victory to get it through Congress, and it's also a political victory to have that legislation take effect. And the Supreme Court upheld that procedure too. Another thing that Congress can do to protect its legislation is just to tell courts, when you review this legislation, here is how you should review it. Here's the evidence you can consider. Here's the standard of review you can apply. Here is, can the other side have a lawyer? Can, how much time needs to take place, or how much time needs to pass before you can make this challenge? So can you challenge it within a week after it passes, or within a year? And Republicans historically have just been very, very good at this. So one example is EDPA, the Anti-Terrorism and Effective Death Penalty Act of 1996. EDPA, the entire purpose of EDPA was to make it more difficult for people who have been convicted of criminal offenses in state court from challenging the constitutionality of their convictions. So before, if you were convicted, you could say, this is unconstitutional. Federal court, please grant me relief. And after, federal courts can grant relief for second or successive habeas petitions only if there's a clearly established violation of the Constitution, according to the Supreme Court. So the entire purpose of that law was just to make it more difficult to challenge things that the GOP-controlled Congress didn't want to be challenged. Immigration law is full of examples of sort of jurisdiction stripping or jurisdiction channeling that changed the standard of review to make it harder for immigrants or for people caught up in the detention system to get relief. And so there's just no reason why a Democratic Congress could not do the same with respect to something like H.R. 1. More aggressive reform on the table is jurisdiction stripping. So the Constitution specifically gives Congress control over the Supreme Court's appellate jurisdiction. And after the Civil War, when the Supreme Court was about to hear a challenge to the Reconstruction Acts. So these acts that required states in the former Confederacy to, for example, allow Black people to vote and participate in creating multiracial constitutions. That went up before the Supreme Court. One provision of the Reconstruction Acts went up to the Supreme Court. The Supreme Court heard oral argument, and the justices were like, I don't know, we don't really like this Reconstruction business. So what did Congress do? Did they sit on their hands and allow the Supreme Court to invalidate Reconstruction? No, they said, you can't do that, Supreme Court. And so they just took away the jurisdiction. They said, given how this case reached the Supreme Court, that law is no longer good law. And so the Supreme Court said, well, we can't decide this case because Congress just took our jurisdiction away. And more recently, the court, even Republicans on the court or Republican appointments on the court have said, Congress has the power to basically change the rules that apply to existing litigation. So Congress can just say, look, if you want to challenge the constitutionality of this law, you can, but you have to do it in the courts of appeals. You can't do it before the Supreme Court. The Supreme Court itself has said we have this power. A slightly even more aggressive reform on the table than jurisdiction stripping is a supermajority requirement. So Congress could say, look, Supreme Court, you can take down statutes, you can exercise judicial review, but when you do so, you can only strike down a law so long as 6 or 7 or 8 or 9 justices agree that the law should be struck down. Otherwise, you lack the power to issue an injunction. And so this is sort of a complicated reform, because it's untested at the federal level. So states like Ohio and Nebraska and a few others have successfully done this at the state level, but sometimes with constitutional amendments. Whereas at the federal level, if Congress were to pass a law saying that this law can only be struck down by a 7-2 vote, that might be easier to challenge. Although all of these would be easy to challenge, they also have precedent. That doesn't matter. The point is, what can Congress do to protect itself from these challenges? But the idea behind a supermajority requirement would be to say, courts, you always say that you defer to the elected branches. This is what Republican appointments on the bench have been saying for the past 50 years. So now you can review laws passed by the elected branches, but you have to do so deferentially. And unless this is just totally unreasonable, such that even a bipartisan consensus of the court thinks that this is unconstitutional. If that's not the case, then you don't have the power to invalidate us. And then the last thing I'll just mention is something I like to call death by 1,000 cuts, which is just taking advantage of the fact that the Supreme Court are like currently 8 very old people who don't have the capacity to review everything that's happening in the country. So right now, the courts, every justice on the court has 4 clerks. They have a summer vacation that lasts for 3 months. They have discretion over the cases they hear, so they can choose whether or not to take a case. 100 years ago, 200 years ago, none of those things were true. And so Congress could put like a real originalist move and say, no more clerks for the Supreme Court, no more discretionary jurisdiction, and you have to ride circuit. So you have to go around the country and hear cases in local courts. So you can't spend all your time invalidating what Congress is doing. So just pack the Supreme Court's time. Just say, look, it takes effort to figure out which laws you want to strike down. And so now you don't have that time anymore because you're riding circuit around the country like your predecessors did in the 18th century. So there's just like a lot of options on the table. It's not just like disempowerment. And Congress should do one of them as opposed to just letting HR 1 fall by the wayside.
I am really enjoying the image of Justice Roberts like riding a horse from circuit to circuit.
That's the most originalist way to ride circuit.
Yeah, of course. We're just doing the originalist thing here. Well, this is incredibly helpful, and I think that thank you for both laying out the immense array of options that are on the table beyond just packing the courts. So I want to, as we're wrapping up, take a few minutes to talk about some of the fears that progressives might have about these ideas and the risks that, people might worry that they pose to our communities. So what do you say to people who fear that the GOP will retaliate to court packing or other court reform proposals, and they'll have an advantage because the Senate leans conservative and it leans white?
So just quickly, I think, again, the idea that we're starting this and that the Republicans would be responding in kind is simply not true. This has been started. We are seeing the fact that the Republicans have treated the courts as, a branch entirely within their control to do as they will with for years. So to not do anything is the outrage here. To act like we can just go back again to business as usual in 2014, 2015 is simply laughable, because the Republicans have been throwing our democratic norms out the window for years. The other thing that I will say, right, is that fixing the courts is not enough. We also need to ensure that our democracy is actually working, and that's why I've been talking so much about HR 1 tonight, because right now it isn't working. And so we do have a Senate that is completely unresponsive to the will of the majority. We have, anti-democratic institutions that are stopping the people from being heard, and that needs to change as well. So, right, we need to have everybody who wants to be admitted as a state admitted as a state. DC needs to be made a state. We need to have 2 senators from DC. If Puerto Rico chooses to become a state, Puerto Rico should be admitted as a state. We need to ensure that people can actually vote, right? Like right now, we know that people who are eligible voters are being tossed off the rolls in states around the country. We know that people who should be able to vote are being disenfranchised by, by disenfranchising people who are convicted of felonies. So changing the shape, changing the nature of our courts is part of the solution here. And it's an important part, obviously. That's why we're having this panel tonight. That's why we're all here. But it's only one piece of this picture of making sure our democracy actually functions. And so I think this idea that the Senate will always look the way it does, that Mitch McConnell will constantly be ruling the Senate, and the second they get their majority back, they'll be able to do what they want with the courts again. I don't think that's true if we do our jobs right over the next 4 years, if we get there.
Great. Thank you. I couldn't agree more. I was also wondering if you could speak to some of the, the risk that if the court isn't a stronger check on Congress or on state legislatures, what we can do if people like Trump and McConnell come back to power and are targeting immigrants or restricting abortion access.
Yeah, so I think the sort of argument I've heard the most when talking about reforms to disempower the court is the sort of classic West Virginia versus Barnett understanding of what the Constitution is for. And the idea that the court articulated in that case was the purpose of constitutional rights is to take things out of the democratic process and hold them up and protect them from temporary majorities that might make bad decisions. And I think it's definitely true that judges protect minority rights. The problem is that the minority that judges protect most often are plutocrats. It's just like wealthy, really powerful people consistently take advantage of the protection of the courts to protect themselves from redistributive legislation, from laws that transform power or that expand the franchise, laws that transform democracy and make it more equitable. And so I think there's no escaping the fact that if you allow legislatures to pass laws, many of the laws they pass will be bad. Just that's how democracy works. But I think in this country in particular, we have a history in which Congress, in which the federal government has stepped in and attempted to redress a lot of the problems at the state level that the Supreme Court, when it has gotten its act together, has had to step in. So Roe versus Wade, Obergefell I mentioned at the beginning, are examples of things that Congress, if it had not already been disempowered by the court, could have stepped in to fix. And so I think, figuring out how to protect minority rights, protect the rights of the vulnerable in a democratic government is just like a really important challenge that is not going to go away with any of these reforms. It's not going to go away by ignoring the reforms. It's not going to go away by employing the reforms. And so we have to ask ourselves, what is more important? A government in which the right of a woman to obtain an abortion depends on this, really just crazy appointment process of these super credentialed people who have spent most of their careers not saying anything in order to get on the court in the first place, or the democratic process in which people mobilize their neighbors and get out to vote and push people to defend themselves and to explain, look, this is what I believe in and I want you to believe in it too. And we're going to use our democracy to ensure that our rights are protected. And then just the last thing I'll mention is the sorts of rights that are created by the judiciary are weak rights. They're negative rights. They're rights that you cannot mess with somebody. They're libertarian rights, which are frankly not the rights that society in which people mutually depend on each other need. We need affirmative rights. We need rights to housing. We need rights to healthcare. We need rights not only to have the right to choose to have an abortion, but the affirmative access to it if we don't have the money to afford it. And those sorts of affirmative rights are the products of legislation. They're not the products of judicial review. And so if we want a country in which people in government are actively moving toward helping people reach their potential of providing the affirmative things that we think everyone should have, we need empowered legislatures that aren't always fearful that a court with a history of protecting property rights above all else is simply going to overrule whatever they choose because they disagree with it.
Thank you. So we are running up on our time. So I want to take a second to ask all of you to join us in the two tasks that we have before us. So the way we see it at PPP, we have two urgent things that we need to do. First, we need to stop Amy Coney Barrett or whatever right-wing ideologue Donald Trump announces this weekend. Our immediate task is we must stop that nominee because lives are at stake. Republicans on the Judiciary Committee are trying to ram through a vote on this nominee in October. So our window is small, and this is going to be an uphill fight. And I'm just going to level with you. To win, we need to make sure 4 Republican senators vote against this nominee or against confirming someone until the next inauguration. That political map does not look great for us. Senators Murkowski and Collins have said that they won't support a nominee until the election, but even they haven't committed to waiting till inauguration. So in 2016, Republicans stole a seat on the Supreme Court by saying no president should get to nominate someone in an election year. And a lot of Democrats are standing up and saying, well, we got to tell Republicans to keep their word. And Mitch McConnell does not care at all if he breaks his word. He will serenely hold these sham hearings as soon as he can, and he will pop a bottle of champagne. The only thing Republicans care about is power. And if we're going to stop this, we need to build and exercise people power. It's the only choice that we have left. And that means we need to demand Republicans oppose this nominee, and we need to demand that Democrats fight this thing hard. So if you're in a blue state, you still have a job. We need to demand that they do things like slow the Senate down by withholding unanimous consent. We're working with partner groups like the Center for Popular Democracy and Demand Justice to organize mass direct action targeting key Senate votes. That's not just people who are up in 2020. We also have to target people who are up in 2022, because we probably will have to go after people who might lose this cycle. So that means we need a huge movement very quickly all across the country, because we need every single senator to know that if they vote to put someone in Justice Ginsburg's seat this fall, we are taking away their seat. So that's task 1, stop this nominee. But task 2 is to recognize that, we may or may not win this fight. And whether or not we win, we are facing a judiciary that is already undermining choice and voting rights and labor power. Whether or not we win, Donald Trump has appointed 1/4 of active federal judges. And whether or not we win, the courts are not going to save us. They are not on our side. And we need a movement that is fighting back against judicial rule to unrig the legal system. It's not just an academic fight. These are real stakes for families that are being crushed by stagnant wages, and for people who can't afford to get healthcare, for people who have no recourse when the cops storm into their homes and shoot them in the middle of the night. So we're using the last minutes of this Zoom to ask you to be part of this movement. Tonight, PPP is launching our Unrig the Court organizing network. My colleague Vale is going to drop a link in the chat to join our national Unrig the Courts organizing Slack, which we will also be circulating by email. We'll be organizing law students and lawyers across the country for systemic changes to stop the court from weaponizing their ideology against working people and people of color. We are asking you to be part of this movement, and no matter how much experience you have organizing, no matter what kind of work you're most comfortable with, I promise you there's a place for you in this movement. We need people who are going to throw down and plan a huge direct action. We need people who are going to do a lot of research and help democratize these ideas. We need people who are going to have teach-ins in their community, and I promise there's a way for you to plug in. If you're not sure what organizing would look like, we also have good news for you. This Saturday, Sunday, and Tuesday, we are hosting 3 organizing boot camps for people who want to be part of our network and who want to start scaling up their organizing on this issue ASAP. If you can't make those times, don't worry about it. Email us. We are here to be a resource to you so that you can organize your community for these 2 urgent tasks. So if you are interested in being part of this movement, do me a favor and use the little hand raising icon in Slack so that we can see that you are on our side, and sign up. Oh, wow. This is amazing. This is like dozens of people. You love to see it. And then sign up for the organizing Slack and these organizing trainings. We are here to be available to you if you're still thinking through these ideas. We'll also send around some written resources. And thank you all so much for joining us. And thank you to our panelists for sharing their wisdom. All right.
Thanks so much, everybody.
Thank you.